Morning, if you would join me in rising for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. What was that, a harmony? With that, I'll open the continued public hearings on bail reform. This morning, I understand we have some folks here from the county, and I would invite them to come up to the mic. And I believe Mr. Halverson first. Morning, if you would introduce yourselves and tell us all you have to tell us about bail. We'd appreciate it.
Paul Halverson, County Attorney for Merrimack County.
One of the things that we had talked about that we thought might be helpful is just sort of talking about the background of what happens when you get arrested. Essentially, there's a couple different ways to get arrested. If you're sort of caught red-handed, the police can take you into custody, or police may apply for an arrest warrant, take you into custody on the warrant. But once you're arrested and you're brought back to the police station, they go through a booking process. During that process, the police are obligated to call a bail commissioner. There's a statute in New Hampshire which requires the police to notify a bail commissioner and notify a arrestee that they have the right to a bail commissioner. The bail commissioner is supposed to respond to the police department and essentially sets bail on the arrestee. The bail commissioner has a couple of choices. They can set preventative detention, they can set cash bail, or they can release the person on personal recognizance. If a person is held, meaning either held on preventative detention or held on cash bail, they're entitled to a hearing within 24 hours, except weekends, in front of a judge, where a judge would decide bail or whether or not bail is appropriate. And at that hearing, the complaints would have been filed already in the court. There'd be a prosecutor there and potentially a defense attorney. If the person's released on personal recognizance bail, the bail commissioner gives the arrestee an arraignment date. There's one of the rules of criminal procedure indicates that that arraignment date shall be no sooner than 35 days from the date of arrest. So if you're arrested October 1st, your arraignment date is going to be at least November 6th and can be further out than that. If personal recognizance bail is set, what ends up happening is the police department then transfers that paperwork to the prosecutor's office or files the complaints in court. There's a rule that says the complaints have to be filed no less than 14 days prior to arraignment. So again, in that October 1st scenario, we would be filing the complaints no less than 14 days before that November 6th arraignment. What that means is that there's a gap in time often between if a bail commissioner releases someone on personal recognizance bail and when that case is actually received and reviewed by a prosecutor. There are certainly provisions in the statute that indicate if the state feels that personal recognizance bail was inappropriately set, we can file a motion to have that bail reviewed by the court. The statute indicates that review should happen within, I believe it's 48 hours. The difficulty is that there's already that gap that's occurred within those 35 days. So we're not immediately hearing about the PR bail usually. Once the person is arraigned in court on their regular arraignment, the court can modify bail. I would indicate that at least in my experience, has been very seldom will the court modify bail at a normal arraignment. People can file motions for bail review. The defense can file a motion for bail review. The state can file a motion for bail review. Again, it's been my experience that if the defense files a motion to have bail reviewed, that's generally held within 24 hours. my experience as the state has been that when I filed motions for bail review, it's been significantly longer to get them scheduled than 24 hours. So that's sort of the background of where you start.
If I may interject,
Yeah.
one of the ideas we've contemplated is giving the prosecutors the ability to appeal and the defendant on certain limited enumerated crimes be held pending that appeal. If it's in the circuit court to the superior court, and that seems pretty clear cut. The question I have is, how often are these already in the superior court, and what would then be the avenue of appeal? All that's left is the Supreme Court, which would clog their calendar insignificantly.
So there's already a statute that allows the prosecutor to appeal a bail commissioner's decision, whether it's in circuit court or superior court.
I meant the judge's decision.
So you'd appeal the judge's decision to.
So at arraignment or at the first appearance, the judge doesn't modify PR bail, and the prosecutor objects.
Yeah.
Expediting that appeal to no more than 48 hours to superior court and the defendant be held.
You could.
What were your thoughts on that?
I don't see a problem with that necessarily, other than would you be having superior court judges, for lack of a better term, second guessing other superior court judges?
That was my question.
Right.
If it started in so with the end of felonies first, more of your arraignments are going to
You're
occur
gonna start in circuit court.
So that would significantly impact that. But how many do start in superior court?
Right now, all felonies start
Yeah.
in superior court.
Right.
So the felony level bail prior to felonies first being eliminated starts in superior court. So you have superior court judges in the first instance setting those bails.
Mhm.
In terms of having an appeal to the Supreme Court, there's already a statute 597(6)(e) that talks about an appeal to the Supreme Court. It says it shall be determined promptly. I think that promptly to the Supreme Court means something different than promptly to most other people.
I think as soon as we can, maybe.
I know that the case up in Coas County where the individual had hit the motorcyclists had appealed his bail to Supreme Court, and I think that appeal was resolved in a 4 to 6 month period, which I think may be prompt for the Supreme Court, but certainly doesn't meet the colloquial prompt.
And there's a question too, is if you have a appeal to a Supreme Court out of a circuit court order within 48 hours, that can be an evidentiary hearing that requires witnesses. Because I think each side, if that's the issue, may or may not have difficulty getting appropriate witnesses there within 48 hours.
Well, again, though, with the end of felonies first, I'm foreseeing hopefully within the year, the arraignments in the first instance, even for felonies,
Right.
would begin in the circuit court again.
Yes.
So it would be an appeal to the superior court, which would be much more doable
Right.
and reasonable.
And as I indicated, 597(6)(e) already has that process
But
in
not the
place,
hold.
but it doesn't have the hold in place, like you said.
And that would be only in an extremely limited series. I mean, it wouldn't be able to request it on every case, but in limited number of cases that were violent or a danger to the public, that the prosecuting attorney could say, we just don't agree, Your Honor, and we'd like it to be reviewed. So barring getting into the quagmire of the Supreme Court, it's certainly a doable idea then. And would it help the state in keeping more people off of the street who probably shouldn't be there?
Potentially.
That's why I ask.
As I'm thinking through what you're saying as you're saying it, I think you could certainly have a statute that stays the decision of the circuit court pending the appeal. So if the person was held and the circuit court judge said personal recognizance bail, you could appeal that and stay that personal recognizance bail pending the appeal. I think it becomes more problematic to say that the person's held pending an appeal
when they were free.
Because you could certainly have a situation where a person is granted PR bail by the bail commissioner, comes into court, is granted PR bail by the judge, and then having the state say, we're going to appeal that, having them automatically held, I think could be potentially problematic.
And along that same line, granting the ability of the police to appeal a bail commissioner's decision, likewise with a very limited set of criminal, where they would be held,
Yeah.
but within the same 24 hours, except for requiring the court to hold hearings over the weekend, so that it wouldn't make them stay over the weekend. The
Maybe I
court,
misunderstood what you just said, but if they're held, they're in front of a judge the next day anyhow.
unless it's a weekend.
Right.
And what I'm contemplating is requiring the courts to hold some type of a bail review over the weekend. The question is, would that trigger the full panoply? In other words, would they get a defense counsel? Would they get witnesses? Or could it just be a simple review of a bail commissioner's decision ex parte?
I don't think you could necessarily do it ex parte. I think you could have a review of the bail commissioner's decision within 24 hours, even on weekends.
Mm-hmm.
The sort of practical difficulty with that is we don't work on weekends. Tends to be the difficulty is, we were talking earlier that prosecutors tend to be salaried, judges tend to be salaried. I think you potentially have to have that be an open hearing, a public hearing, which means you'd have to have it in a courthouse with court security where the public was allowed to attend.
I would question, and I know this, it's a different state, but it still falls under the same constitutional rights overall. I know in Massachusetts, they have something called the Jenkins Rule, where if someone's to be held more than 24 hours, a judge telephonically speaks with the police as a review, and all those other hearing rights aren't triggered.
And I think in that case, you'd essentially be having the judge setting bail.
Indeed, yeah.
Right.
In lieu of, if the police objected to
Right,
a
in lieu
proposed
of bail.
personal recognizance, the police said, well, we would like the judge to do it.
Yeah.
Um,
And that may,
which would alleviate the second concern of having to take someone into custody at court who was
Right.
already free.
right. No, you could certainly have, again, the status quo in place, which is that the person is in custody, and then have an on-call judge review that bail decision or set bail.
Because we already have judges issuing emergency protection orders over the weekend. If a judge were to say,
Right.
okay, every Saturday morning I'll hold bail hearings for 2 hours or whatever they end up working out. And I do plan, obviously, to speak with the Supreme Court justice about this, but it's just ideas that are bouncing around.
Yeah, I think there's a difference between the initial imposition of bail by a judge versus an appeal by a judge. And going back a little bit to your question about doing it ex parte, I don't think that's a good idea. Frankly, I think it's a bad idea because it stops the accountability of the individual who's setting the bail, which I think needs to be open and clear to outsiders. Someone who's not involved in the process should be able to watch that process. That's the main concern that I have. It should be open and clear for the accountability and for continuity.
But if it's in lieu of the bail commissioner,
If it's initial setting, I think it's a difference.
okay.
Because the initial setting, you're able to appeal it in front of a judge, in which case it would be in open court during open session. The initial setting of the bail may be at 11 o'clock at night, and it would be appealed to the next, or reviewed
Well,
in the next session, however.
And again, this would be an extremely limited set of
And-
crimes.
and it may be a distinction without a difference in terms of ex parte, because when the bail commissioner is there, generally the defendant is going to be sitting in front of them and the police are going to be there as well. So,
Okay. But a right to counsel hasn't yet attached is the question. There is no right to counsel before the bail commissioner, just because one is a judge versus a bail
there
commissioner.
is no right to counsel until the complaint is filed.
There we go. Okay. Thank you. Please go on. I didn't mean to interrupt. If I threw you off track, I apologize.
Do you have anything else?
I mean, I have nothing else. I'm happy to answer questions or.
Well, one of the concerns that we've discussed is, in the Senate bill, one of the ones that we're contemplating here, they have a list of 13 crimes. I'm sure you're familiar with it. It's our impression that it's not those 13 crimes that are driving the public consternation with the bail situation. It's the repeated nuisance crimes. It's the trespass. It's the shoplifting. It's a disorderly person that are occurring while people are on bail again and again. What are your information can you give us about that?
Well, and I think another part of the frustration with the bail system is non-appearances in court. In Merrimack County Superior Court, everyone who's arrested, released on personal recognizance bail is given an arraignment date for their felony. Those arraignments occur on Thursday afternoon. So yesterday we had an arraignment session. There were 13 cases scheduled for arraignment yesterday. Out of those 13 cases, 4 of those individuals had obtained counsel. So the 4 individuals that had obtained counsel, 3 of them waived their arraignment, 1 continued their arraignment, which leaves 9 of those 13 cases. And we could play any guesses on how many people actually showed up.
Of
But-
the 9?
Of the 9, 1. So we had 1 person show up for their arraignment and 8 failures to appear yesterday
And they were
on,
all bench warrants issued?
yes, on felony level PR bails. And I think that's a frustration.
Well,
Did the-
hopefully the bench warrants are issued.
Did,
Well,
did the
reason
judge,
why-
Right.
did the
reason why-
judge that you know of set conditions if they were picked up on the warrant?
So we would request bench warrants with
No bail.
no bail. So theoretically, when they're picked up, they'd be a hearing in front of a judge within 24 hours to set conditions of bail and set bail. The frustration is that a lot of those people get picked up and get released again on personal recognizance bail or get released on, bail with conditions. And we may find out that they're violating the conditions of bail and file a motion to revoke bail. And the frustration again becomes that those motions aren't necessarily heard in a timely fashion. It may take, I've certainly had the experience where the court holds the motion for 10 days to wait for defense counsel to respond. And then by the time the judge gets it, it's 10 days old. And the judge says, well, we'll schedule a hearing. And I may get a hearing 30, 45 days out
To revoke bail.
to revoke bail. So, and inevitably, the defendant doesn't show up at their motion to revoke bail hearing, and we get a no bail bench warrant.
How often is no bail set on the bench warrants for failure to appear?
Fairly often. We do have a lot of bench warrants with no bail set. And I think that that's, in my experience, and correct me if I'm wrong, I think that's almost the default for our Superior Court judges, at least in Merrimack County, that their feeling is you have to go in front of a judge since a bench warrant's been issued. And you may get PR as a result of that hearing, but initially you're going to be held no bail pending that
Or at least the
warrant.
warrant's going to issue for no bail. I would point out that the attorneys in the office, if they get a call, if a person doesn't show up, no one knows where he is, where that person is, and a no bail warrant issues by the court. If something happens 2, 3, 4, 5 days later, defense attorney calls the involved prosecutor and says, hey, I found out what happened, and they have a valid reason for it. The attorneys in the office are pretty flexible about agreeing to reschedule, to vacate a warrant, and to reschedule if there's a reason. But I think Steve's right that the vast majority at the initiation are a hold or cash warrant.
If you could, how often does it come to your attention that these defendants are homeless? They don't have an address?
It's fairly common.
Frequent.
Yeah.
Yeah. Matter of fact, I just got, I saw a spreadsheet the other day from Concord Police Department that talked about the frequency of arrests on new charges, breach of bail, and failures to appear on bench warrants for folks that don't have they have more of a fluid address. They don't have a static address. And the numbers I saw covered, I tallied them up last night, from January 1st of 22 to August 16th, there were several hundred entries, but there were 113 bench warrants between January and middle of August. And my interpretation of the spreadsheet was those bench warrants were not new warrants for new arrests. They were bench warrants for non-appearance in courts. And there were 39 breaches of bail for non-compliance with the court orders. Now, there may be some overlap with those numbers, but those are the numbers from just one police department in the county. The other thing, I also did a quick email to the attorneys before I came today. Last couple of days, I got some responses about how their requests for warrants and requests for revocation of bail is being processed by the Superior Court. And I can give you a couple of examples, just the feedback I got back. One individual, 5 open cases, 7 failures to appear, and the concern there is 5 open cases, 7 failures to appear. A motion to revoke was filed on 5 failures to appear. One person from a 2020 case had a cash bail issued of $1,000. That was posted after failures to appear. The state did a motion with the court to forfeit the $1,000 back in April of 2023. We've yet to have that scheduled. Court's not been scheduling that. In district court, after 4 failures to appear, $300 cash bail warrant was issued, but again, the judge held that for 10 days. I assume, in keeping with what Steve mentioned a moment ago, that was probably time for defense counsel to get information about the individual. One attorney filed a motion to revoke in June, filed it electronically. It was filed on June 22nd. It was not accepted by the court until July 18th, almost a month.
Accepted? You mean,
They file it electronically, and the court has to accept it prior to them moving it along within the court system.
so even acknowledging that they received the electronic filing
Correct.
took a
Right.
month?
They didn't acknowledge that for just shy of a month. Another individual dating back to 2020 failed to appear back in 2020, picked up on the August. I mentioned him, the guy from non-appearance out of state. Motion to revoke bail had gone AWOL from pretrial services. Another attorney has filed at least 7 motions for absent without checking in with pretrial services. Whereabouts are unknown. From my perspective, talking with the attorneys, there appears to be a big continuity issue with the judges and the courts, how fast they accept it, how fast they schedule it, going back to what Attorney Enders mentioned a moment ago. Defense attorneys file a motion to review bail. They get 24, 48 hours, 1 or 2 days. It's in front of a judge. The state files a motion to revoke or a motion to amend. We won't see a notice for that, maybe for, or a court schedule, 2 weeks, 2.5 weeks, if they even accept the pleading in a timely manner. There's no continuity, and I think that the system, in my opinion, the system works generally well the way it's set up, but there's a lot of loose ends in the system that public policy-wise need to be tightened up.
So what I'm hearing so far isn't necessarily any kind of repudiation of the bail statutes themselves as much as the way the system interacts within its own pieces.
And I think that's true.
As do I.
I don't think the bail statute is fundamentally flawed as it's written. I think it's got a lot of good stuff in it. The difficulty is that there's a lot of discretion along that road.
And that's what we'd like to maybe do is fine tune, not
Right. One
rebuild.
of the things that always sort of struck me was that there's a massive amount of training required to become a police officer in the state of New Hampshire. They go through the academy, they go through field training. So you have very highly trained police officers. In terms of becoming a judge, I don't think there's any requirements, but you get appointed by the governor. I think all the judges in New Hampshire at this point are attorneys. You have highly experienced, intelligent judges. You have highly experienced, intelligent prosecutors. And what always struck me as odd among that system is the person who decides whether you go home at night after you've been arrested is the bail commissioner. And the educational requirements for bail commissioners in the statute are a yearly meeting and a bail commissioner handbook. There's no 100 hours of training. There's no there's no educational requirements there. And I'm not saying that the bail commissioners aren't trying to do a good job or doing a good job, but there's a huge amount of discretion there. And you have people from various backgrounds. I know throughout my career as a prosecutor, there was a time when most bail commissioners were retired police officers. That's changed. And there was a time when most bail commissioners were court personnel who had been appointed to be bail commissioners. So there's a wide variety of people who are in that role.
Mhm.
And I think that they're given an incredible amount of discretion with very little sort of objective criteria to say, here's a form or here's something to consider in terms of if you get so many points, you're held or you're not held.
Yeah, and to their credit, the bail commissioners themselves have asked for more training and more continuity in their training. And we are taking that very seriously
Yeah.
as well. But also, you mentioned that many bail decisions of the commissioners aren't being overturned. So we can at least assume, arguendo, that the decision was correct, or at least not so far out the bounds that it's cried out for reversal.
And I don't disagree with that. And it's sort of a cyclical thing where what ends up happening is if a bail commissioner sets personal recognizance bail, like I was saying, there's this lag between when I get it as a prosecutor. If I file a motion saying the bail commissioner got this totally wrong, and I end up in front of the judge and the defendant appears, the argument's going to be
He's been good.
he's been good for 30 days and he's here now.
Yeah.
Obviously PR was the correct decision.
Yeah.
So
It's in the one time it wasn't the correct decision.
right, it's
that
the
we-
one time or the two times and I think that there's different between the person who's released on personal recognizance bail and commits further crime, and the difference between the person who's released on personal recognizance bail and doesn't come to court because, for lack of a better term, their life is a mess, and getting somewhere on a day they're supposed to be there is virtually an impossibility for that
Monumental,
person.
yeah. Well, that brings us back to the two original. You're held because you're a danger or because you're a flight risk. If you don't show up, you're a flight risk. If you repeatedly don't show up, you're
Correct.
And if you are but the question becomes then the danger. On one level, we discuss danger as in, are they going to hurt somebody? But the continued breach of the public peace, in my mind, is also on a certain level of danger. If they keep getting arrested for shoplifting, if they keep trespassing, it eats police resources, it eats court resources. It puts police in danger every time they have to take someone in custody. So the question is, how do we, and I don't mean to put you on the spot,
Yeah.
but if any suggestions from you who are in the trenches would be greatly appreciated on how we could fine tune that.
Yeah, I agree with you that I think multiple failures to appear does put you in danger. I think that there's a certain level of sort of personal debilitation that comes with being arrested multiple times. And I think this sort of overlaps too in a little bit of like the mental health system. But we have people who, fail to appear, keep committing crimes, get arrested, end up being held in jail. And that's the argument, that they're a danger to themselves because they essentially can't live harmoniously in society as we've established it. I don't know where that line is, where you've become a danger from multiple failures to appear, but I've certainly made that argument in the past.
What about services? Because as we've established, or I believe the record has established, that the majority of people that are picked up like that are in need of service, either
Yeah.
substance or mental health.
No doubt.
Yeah.
No
So
doubt.
what is available? I heard you mention pre-trial services. Could you
Correct.
tell the committee what that is and what's involved with that?
So in Merrimack County, we have a pretrial services program where you're subject to essentially pretrial monitoring it's almost like a pretrial probation, for lack of a better term. There are components to pretrial services. You have to check in. Those check-ins at this point, I believe, are telephonic. there was a time when pretrial services would do home visits. I don't believe they're doing those anymore.
That stopped around COVID time.
Yeah.
Any plans to take it back up?
I think there is, but within Merrimack County, the pretrial services folks used to be sworn deputies. The pretrial services changed their wiring diagram within the county, and I think they're going through a certification now through, I want to say, corrections, because the concern is that if they go to someone's house, we're dealing with individuals who are in front of the criminal justice system, and that may not be receptive to having someone coming to their home. And having a single person who's unarmed going to a home of someone who doesn't want them there may be problematic. So I think they're in the process of reestablishing some way to allow the individuals to protect themselves.
What about drug screening while they're on this?
They do. So they do urine screens while you're on pretrial services. They offer drug counseling.
Electronic monitoring.
Right. We can do electronic monitoring, which can include a GPS bracelet so that you can sort of geofence people to say
Work home.
you can't go to certain locations, and there would be an alarm if they went within a certain distance of a location. There's also a requirement that you're employed or in school during pretrial services. So the courts certainly have that available. I think for me, one of the difficulties with some of the pretrial programs is that the idea behind it is that we're going to take people who would otherwise be incarcerated and put them on pretrial services and allow them in the community. But the reality is that what ends up happening is you have people that would otherwise be out on personal recognizance bail unsupervised are the ones that, at least in my opinion, make up the majority of pretrial services. And I think those are the people that really could benefit from pretrial services. Certainly I'm sure someone behind me will mention that, and probably knows far more about this than I do, but there was some program in New York City where they simply texted people the day before their court date, and their failures to appear dropped drastically. And I think that one of the benefits of pretrial services is you have someone there to remind you of your court date and to say, we want to make sure you're going to court tomorrow.
And you know exactly where they are if they wear an ankle bracelet.
Yeah.
You also mentioned services generally. I know that over the last year or so in Merrimack County, the human services folks have redesigned their structure, and they have now it's called a County Navigator program, which takes referrals. They'll take referrals from law enforcement, self-referrals, public defender, defense counsels. You don't have to be law enforcement involved to get a referral to them, and they'll help navigate the services within Merrimack County, help people establish appointments, seek housing, food assistance, medical assistance, items such as that. It's working very, very well. They also do drug assistance. You'll remember when the opioid money started coming from the opioid lawsuits started coming, some of that was earmarked to my office. But because of the requirements within the statute, I didn't have a program I could plug that money into. I worked with the human services folks, moved that money from my budget to theirs, along with they received, I understand, additional opioid money, and that helps fund some of the medical treatment and the drugs treatment, substance abuse treatment and mental health treatment that's available through the Navigator program, or at least the referral process and backfilling costs.
So it sounds like Merrimack County has some really innovative, good things going on. The problem is that we write statutes that cover the whole state.
Right.
So if the other counties don't have it, it's an unfunded mandate, and it's a problem.
Right. And at this point, the pretrial services program is a county by county program.
Right. But ours is pretty robust. As a matter of fact, I think they just recently won the Navigator program, and Human Services just recently won an award, national award, for their programming. So it's pretty robust. Pretty robust.
At this point, I'd like to open it up to members of the committee to ask questions. Anyone have any, since I've been hogging all the time?
Can I make one more comment?
Oh, absolutely, by all means.
Going back a little bit, you had talked about, we had talked about the bail statute pretty much the way it's written is workable. There needs to be some tweaks to it. I know some of the considerations that you mentioned were getting the people who are multiple failures to appear in front of a judge rather than in front of a bail commissioner. Remember, bail commissioners are a statutory, their duties are outlined by statute. There is a way that you may want to consider of, with certain parameters, bail commissioners unable to set bail, it goes in front of a judicial officer the next day under the bail commissioner statute. Limit their authority to set bail rather than change the bail statute as it is. Say, under these circumstances, an individual who's on release from Department of Corrections or on bail for 2 or more A misdemeanors or felonies and rearrested must go, they cannot set bail. Or someone who has committed one of these crimes, is charged with one of these crimes, the bail commissioner cannot set bail. That triggers it going before a judicial officer the very next morning. And that leaves the bail statute as it is and just limits the bail commissioner's authority.
And just directs those
It
most
goes
in
direct-
need of
it goes
attention
direct to
where
the-
they should
to the
be.
judges, right?
Could you, would you mind emailing that to the committee, that suggestion,
I will.
with the statutory notation?
I will.
Questions? Representative Muse?
I just had a quick question. Part of my past experience involves helping large organizations convert paper-based processes to electronic processes. And one of the things that can gum up the works like nothing else are some important processes continuing to be on paper while other important processes continue to be electronic. One of the things that I'm really curious about in this situation, after having listened to you go through some of the delays in processing, I mean, to what extent are we talking about the court system operating in the 1990s while the rest of us are operating in the 2020s?
Maybe.
Yes.
I don't want to give the impression it's all a paperwork, electronic work snafu. Certainly some of it is or may be staffing. I don't know the staffing. I don't talk to the AOC about their staffing. But when my understanding from talking with some of the folks that deal with the Superior Court more directly at night and meeting the attorneys who file things, they prioritize what they're accepting in their electronic filing. I think that my outside view looking in, that prioritization is warranted, but the ability to get through those priorities is staff driven. And that 20 to 30 days to accept a request for a motion to revoke bail is probably staff driven because they had all these other priorities to get through. And right, all those other priorities to get through, so they couldn't get to that individual priority. And Attorney Anderson and I were talking before we came in, and I'll let him elaborate on this a little bit more. The state seems to have developed their electronic databases and systems independent of one another to the point where there are several. And I don't know if they're all talking to one another. I know.
Right. So right now in circuit court, everything is paper. So misdemeanors, violations, all that is paper, and it's the same system now that it was 20, 30, 40 years ago. So the bail commissioner fills out a form and gives you your court date on, like, here's your paper form court date. And then the bail commissioner has to then get themselves to the court to give the other copy of that paper to the court, so the court knows this is when it's on. I believe it's still a 3-piece, pink, yellow, white form where the yellow copy goes to the police, the pink copy goes to the defendant, the white copy goes to the court. In Superior Court, they've got electronic filing. That, I don't believe the bail paperwork is being electronically filed. I think that's still, yeah, it probably varies based on where you are. And then the Supreme Court has an electronic filing system that's different than the Superior Court's electronic filing system. So, you need a separate login to get to the Supreme Court rather than Superior Court. There was an initiative at one point in Circuit Court called J1 that I'm not fully familiar with. But J1 was going to be an electronic filing system. And I know that we've got a couple departments in Merrimack County that use J1 and electronically file. And it's been my experience that depending what court it goes to, there's different rules for J1 or different preferences for J1. And what surprised me is at least one of the courts we're using, you electronically file through J1, but then you have to print a copy of your electronic filing and actually hand it to them because they're still using, everything in file folders. And if it's not in a file folder, it doesn't exist in their world. So I know that the probate court right now, which is a division of the circuit court, was looking at doing electronic filing and I think has sort of a pilot project. But at this point, traditional, misdemeanor violation criminal court, and in the future with the elimination of felonies first, felonies as well in circuit court are going to be filed the same way now that they were in 1982 on a written complaint.
And to follow up on the felonies going back, we had a discussion with some of the folks from the Administrative Office of the Courts recently, and several prosecutors, and the question was raised, are the circuit courts going to allow electronic filing? And I think I was one that asked the question because Merrimack County Attorney's Office, we cover 5 circuit courts in 3 different counties because of the way the judicial districts are laid out. And we go all the way over to Newport and to Hillsborough for our courts. So it's conceivable that we have to have an attorney traveling long distances to get to something that may be an early AM hearing, which we'll get the person there. But when I ask, hey, can things be filed electronically? The generic answer I got, well, that's up to the local clerk.
Yeah.
This comes down to a continuity issue that why can't the circuit courts get something to electronically file? And I don't know the answer to that. Well, I guess I do. It comes down to dollars. But even absent dollars, if there was a way to get it to them, even as a PDF attachment to an email, and then hard copy to follow when the attorney gets there, that allows them to start the process, docket things in, get things moving. Then when the attorney gets there, they give them the hard copy. But I don't think there's any standard.
And that's, during COVID, a lot of the courts had an email that you could file through that email.
Right.
And when COVID wound down, some of those courts told us stop using those emails, and some courts were more receptive to continuing to receive pleadings by email.
But going forward, back to your question, talking about electronic systems, the caution that I would have as an outsider looking into the system is be wary of developing new single systems rather than integrating all of the systems.
Mm-hmm.
I think the former would just keep you in confusion. The court's in confusion. The latter will integrate all the courts. For example, a bail commissioner in Coos County who's going to a small police department in Coos County should be able to see the prior night's bail form that was issued in Manchester, like that, but they can't.
One of the problems that we've discovered is that you can be arrested in Manchester one night and 3 days later get picked up in Portsmouth and they don't know you're on bail.
Right.
They just, so in the bail commissioner's eyes, it's a first offense and unless we heard tales of police officers finding bail slips crumpled up on the floor of the car.
Mm-hmm.
That's how they found out they were on bail.
Yeah.
So it seems this technology issue, at least in the instance of bail, regardless of the rest of it, needs to be fixed ASAP, because to blame bail commissioners for people being released multiple times when they don't know.
Yeah.
Right.
Or police not knowing the conditions of bail set in another county so that they can enforce those conditions and pick someone up seems to be a definite public safety lapse at this point.
And especially as it would relate to pending DB works.
Yeah, exactly. But it's my understanding DV orders are
Yeah,
entered.
handled
so-
separately.
right,
Yeah.
so they, yeah,
Follow up?
Well, absolutely.
So I think what we've been hearing is that the current processes that are used in the court system in New Hampshire, um, they're not consistent. So not only can processes differ between the circuit court and the superior court, but they can even vary within individual courthouses.
Yes.
To a large extent, it sounds like a lot of process gets moved by people in shoes. And one of my questions is, just because a process isn't electronic doesn't necessarily mean it's not reliable.
right.
And so, um, but what it sounds like is because so much in the judicial system happens with paper and paper transfers between people, what it does is it creates what I think what you folks were calling these gaps, where you have one group of people that has the whole story or at least a pretty good chunk of the story, um, and then a whole other group of people who could really use that information, who basically have no access to that information until somehow that piece of paper migrates its way to the right person. And sometimes even after that, it can take weeks or months for anything to happen with it, depending on where it gets prioritized in the court system. Is that a fair summary?
A general, generic summary,
Yeah.
I think so.
Yeah, no,
Okay.
I think that's true. And I've certainly found myself in the position of preparing for bail hearings. And if I have more time preparing for a bail hearing, I've called other jurisdictions to say, hey, do you know this guy? Do you know what's going on? And I'm always amazed at the amount of information I get when I actually have the time to do that, or get someone on the phone who knows what's going on, because it gives you a much fuller picture of what's going on in your case.
And and the information can work both ways. If I'm doing a bail hearing and I have an individual who has 7 different open cases and I see that on his criminal record, if I know he's appeared for every court hearing that he's appeared that was scheduled, that's a good thing, And it changes the calculus that I may have on what I'm going to request for bail. They may be minor offenses. All of them may be minor offenses. He's not committing serious against the person offenses. There are maybe minor property offenses, but he's appearing at every hearing he's going to. That's going to have a different calculus in my bail recommendation. As would the opposite. He has more serious crimes that I don't know about because they haven't made it to the criminal record yet. They were only a day or so prior. I don't have the bail information, and knowing that would change the calculus. And the bail statute itself, I think it says that the person reviewing bail uses all relevant information, and certainly all of that information is certainly relevant.
Thank you.
If the committee's done, may I say a couple of things? Thank you. Most of what I want to say has already been said, but I'm determined to say it anyway. So I am a big fan of education and consistency because Prosecutor Steve just said opened with 35 days. The sign in the Manchester bail compartment, room, cubicle says 45 days. Okay. The other thing is if there's a no-show, we're all fans of due process. You want to hear, we want to start slamming a no-show. I had a guy turn himself in who said, yes, I didn't appear for court because I was in the Essex, Massachusetts County House of Correction. Well, the guy turned himself in. He was a good bet for PR. The last thing, some of the defendants have a curious way of bragging. I always show up for my court dates. I said, That's something to be proud of. You'll always show up for your court dates. By the way, NCR forms, they're gone. We've moved up to Xerox machines now. We're really moving along. Um, I have many times seen non-appearance for court uh, electronic bench warrants. They're invariably, I've never seen a hold. Maybe that's because the police don't show them to me, but it's either a cash bail or PR. And I've not ever seen, again, that's my experience. I don't know what's going on, but look, the real residue that I want to leave is training and consistency. That's the big thing in my book. Thank you for listening.
We did hear that, I think it goes back to counties, whether or not the judges in those particular courthouses say no bail, or they leave them as PR or some nominal cash amount. But we do, as a committee, I believe, have heard, and we observed, because we went on a field trip at the beginning of the year to Concord District Court and saw the list be called off of people who were not there, default. So we understand that is a problem.
Right.
It backs up the system. It causes log jams in the system. And it's definitely something we need to look at.
And training's a huge thing. I know that there's always nuance in statutes. And every once in a while, I think the lack of training shows its head when there's a possibility of a life sentence in a charge, and the person's released on PR bail when the statute says that they should be detained.
Yeah.
That happens every once in a while, and I think that circles around to the training and experience level that we've talked about.
I would have hoped in that case the police would have jumped up and down and pointed to the statute. Representative Murray has a question.
Certainly.
I'm just trying to pull out, like, because we've talked about a variety of different problems in the system. So, like, what are, the big pieces? And, we don't have access to this data. I don't know if you do, but are you seeing the issues being, like, erroneously given PR bail, like, being a huge cause of the issues here? Or is it, like, non-appearance? Like, what are the big glaring issues with the bail system, I guess, right now, in terms of, like, is the PR bail being given too often? When you're talking about bail commissioners, like, maybe we just don't let them rule on certain cases. Like, what are your thoughts on that, I guess?
That's a tough question to answer because there are too many moving parts in each and every bail decision. I think as a matter of public policy, though, there needs to be some line drawn that establishes a public policy where someone is committing enough crimes, there's a default, maybe a rebuttable presumption that they're a danger to the community and need to go in front of a judge versus a bail commissioner. Or that a crime that they commit that's charged is so egregious that you cannot see a bail commissioner, you must see a judge the next morning. Clearly those are public policy choices. I can tell you that it seems to me over the last 3 to 4 years that defendants no longer respect the courts. They no longer respect the court orders. And I think that comes from a perception of nothing's going to be done, I'm not going to be held, why should I not appear? Or why should I appear? I think that circles back to what I mentioned about the multiple non-appearances and multiple new crimes that are being committed. And certainly is a small population that is repeat offenders. We're not talking about the majority of people.
I believe the current statute has a trigger if it's 3 times or 5 times within a certain number of years. And I think we maybe need to look at lowering the thresholds on those.
Right.
But it does contain them currently in the statute, I believe.
But that just creates a presumption that you're a risk of flight, and then the statute says you can't set cash bail that the person can't make.
Yeah, so it's kind of,
And
it defeats its own purpose at the beginning.
that's the difficulty, is you have someone who comes in and says, yeah, I failed to appear 4 times, and I don't have $1 to my name.
Yeah.
That can be interpreted to mean they can only be given PR.
I have, like, kind of a 2-part, I guess. So is it fair to say the majority of the PR bails are not the problem? It's just, like, a select group within this, like, the majority are fine.
1%.
Yeah, I mean, I think the majority of people get PR bail.
And probably deserve it,
and should.
right?
The concern is that some people get PR bail and continue to commit crimes, which is a concern. And then you have people that get PR bail and don't come to court. And I think that the don't come to court group can sort of be further broken down into, there are people who are purposely, dodging court. And then there's a group of people who just couldn't get to an appointment if their life depended on it because that's not within their ability level.
Yeah.
And trying to figure out where everybody fits in that and what the appropriate remedy is, because it's obviously a different remedy for everybody. It's not a one size fits all solution.
Yeah, I think hearing about the pretrial services you guys offer and also what you mentioned New York doing with the notification,
Yeah.
like that feels like both things that we should, explore more and expand on, because it just feels hard to like take, when you have houseless people that get arrested for trespassing for sleeping in a public park, over and over, like what other option do they have available to them?
Right.
Like, can we really just hold them
Yeah,
indefinitely?
I always think back, I had a case years and years ago where I had a young woman who was arrested, charged. She didn't come to court, but she worked at one of the convenience stores in town. And she worked the overnight shift. And all the police knew, like, she was there from midnight to 8 a.m. every single night. Never missed a day of work, but, like, never came to her court dates. And it's not that she's necessarily, on the lam or fleeing law. It's just that she didn't want to deal with court. She didn't go to court. But it's not like we didn't know where she was, Interestingly, the police would go and say to her, you have a warrant, you're under arrest. And she's like, I can't leave. I'm the only one here. And they're like, turn yourself in tomorrow morning at 8 a.m. So.
And the local police, in my experience, at least in Merrimack County, are pretty good about approaching folks that are non-appearances and in an appropriate manner based on the circumstances. That's my experience.
And I believe that may trigger some liability for the police officers, though, once they go up to them and say, I know you have a warrant, but I'm not going
Right.
to take you.
Right.
If he kills somebody later on,
Right.
You're in it.
Yeah, I mean,
It
I
puts
don't think
them
there
in
was
an
any
awkward
concern
spot.
that she was going to kill anybody.
No,
but-
not in that case. But
Yeah,
going
no,
forward-
absolutely.
Yeah, especially where you have issues of mental health.
Yeah.
You just never know. And
Yeah.
that's why I was curious as to what services were available, because it seems to me, circling back to the beginning of this, I didn't hear a lot about, the violence being let out. I hear more about the repeat defaults, nuisance crimes, and what do we do with them? And that's a public policy question, not necessarily going to be answered by bail, because bail deals with flight and safety. So
Right.
we need to figure out how to loop those together so that when someone does become justice involved, they also become service involved. And I think that will cut down on the former. Any, Representative, go ahead.
Thank you, Mr. Chairman. So I just wanted to get clarity on something, and then I also have a follow-up. You said everything in circuit court is done by paper. So does that mean that, and everything in Superior Court has electronic filing, and also the Supreme Court, but does that mean that throughout the whole court system for Superior, Supreme, and Circuit, that all the bail, the notifications for court dates are given with paper? Is there any electronic notification of a court date given to people?
So in circuit court, the hearing notices, and this is again my experience and belief, and I could be wrong about this, but in circuit court it's mailed to you. So it's mailed to your last known address. And if you have an attorney, obviously it's mailed to the attorney. In Superior Court, those notifications are sent electronically. Again, in Superior Court, we're usually dealing with felony level offenses. So it would be emailed to the attorneys and not necessarily directly to the defendant.
And I know for many years in Concord, in the Sixth Circuit Court, Concord, in the criminal arraignment sessions, they would give the individual a paper copy right in the courtroom when they entered their
Right.
plea of not guilty. They would issue them their paper copy right in the courtroom.
Just because we generally didn't have good addresses, or it was hard to.
Follow up?
Yes. And then my second question is overall for the bail system, including people not showing up, the no-shows, how much is this a problem of a decay in society where people, cost of living is going up, more homeless individuals, more crime as a result, people just not, like you said, their life's a mess. They can't, they have no respect for institutions anymore. How much of the problem is that, and not necessarily a structural statutorial issue?
I'd be hard pressed to say there's cause and effect, because I've just not looked at it, to be honest with you.
Yeah.
I know anecdotally, there's a perception among some of the police departments that in the larger jurisdictions that some of the increased thefts are due to drug issues, thefts, selling drugs to buy. There's a anecdotal about that, but I don't know if there's any direct connection. But on a just a how society's running basis, I'd be hard pressed to give you an answer on that.
Yeah, and I think that's hard to quantify. I think, we can all say that there are things that, people might have do or say today that would have been unthinkable to do or say 20 years ago. So I don't know. I certainly think that there is a societal level of respect for the court system that may be declining.
How much of that is self-inflicted is really.
Yeah, I mean, I don't.
And it just so
I don't know.
happens that the decline in that respect is with the same group that
The 1%.
are the,
Right.
right. And to be quite honest about it, it's a very small part of the population, having a very large impact on society.
Which is why we want to figure out how to address these small offenses that are cumulative, and they're like a constant dripping on society and draining resources, and and I believe the cities of Manchester and Nashua are suffering, more than most, and that's why we see people coming forward bringing these bills who you traditionally wouldn't, saying we need help, something's happening. And I don't necessarily agree that it's the idea of personal cognizance that's causing it. I firmly believe that cash, for the most part, is an antiquated old English system of law that really doesn't apply as much nowadays, unless you already are somebody of means where losing that money would hurt you. If you don't have it in the first place, the design is to make you show back up for court to get your money back. If you have no money, setting bail on someone that they can't afford really is just saying, I'm holding you. So let's just say we're holding you. So I think we have to figure out that line in there.
I can tell you that I appreciate what your committee's doing, taking a big picture approach to it rather than a piecemeal approach. I think that's important. I think it's very important.
Or we may have bitten off more than we can chew. I think it's at the point now where I'm going to ask the governor if he might not, in persona of the Pope, and we'll call it Criminal Justice Summit or Council of something, because it seems like every agency or piece of the criminal justice system we talk to says it's broken, but they point at a different part. And I think everybody needs to get together, and it's not going to be fixed.
What I think has happened, the system has developed in an ad hoc way, and I think it's coming to a point where now the state needs to focus how everything is going to make it a consistent way throughout the entire state. With your permission, I'll ask our human services folks to send you information about the programs that they have within Merrimack County. That you seem to, a committee member that seem to have an interest in it.
We do.
I'll send you the information on the bail commissioner issue. And if it's all right with you, Chairman, I have a copy of a letter that I sent to Senator Carson and her standing committee on the judiciary back on bail back in February this year. I'll give that to individuals, and I have additional copies for the members who aren't here.
And when you speak to the person about the pretrial services thing, if they could just give us rough numbers of what the cost is for your county? So we
Sure.
could maybe possibly begin to extrapolate out on a state level what that type of system would
She's very
cost?
proud of that program. She's worked extremely hard putting it together over the last 2 years. It's working very, very well.
It sounds like she should be proud. Thank you very much. Any further go ahead.
Just one last specific question that I had to ask. How much would, and again, you know, dollars, of course, but putting that aside for a second, how much, in your opinion, would transportation or some means of transportation help with a no-show problem, making sure that people who don't have a car or living on the street could be driven to the court in some way?
And again, bringing up we have different populations, and you've got, in terms of no-shows, you have people who are purposely ducking the criminal justice system. Providing them with transportation isn't going to get them there because they're going to duck the transportation. And then you have a population that, you know, just doesn't have the means to get there or couldn't get there. And I think that would certainly help a segment of that population get there.
I believe we already offer transportation. It comes with bracelets, I think. I don't know.
And like looking at, I was saying yesterday, we had, you know, 8 failures to appear out of 9 people. I can't tell you if all 8 of those people that failed to appear are facing homelessness or don't have cars or have other, you know, massive life events that prevented them from being there, or what percentage of those 8 are fleeing justice and not coming to court. But my guess would be that more than 50%, it's a resource issue, that if they were provided a ride or maybe even a reminder, they might show up.
And that's a tough question because in New Hampshire, you have very rural areas. But along those same lines, I know that the Human Services folks, as part of their projects, has been working to expand available transportation systems throughout the entire county. I think they're working on even up into the northern part of the county, coming down into Concord. So I'll make sure when I ask them to send information to the committee that they include what they're trying to do for transportation, because the transportation is also key in the human services side of things, to get the mental health services, to get the drug treatment services, to get the medical services that people need. So I think it's all interrelated.
Curiously, the text idea, how it lowered the appearances, I believe now that there's federal programs where anyone can have a cell phone. I'd be curious to know how many even of the unhoused people have cell phones, because you can get it.
I think, the vast majority of people we interact with have cell phones.
So a text reminder, you know, the night before in the morning of, saying to your court,
Right.
and then maybe one more that says you're now in warrant, could generate, even if it cuts a percentage of the no-shows,
Yeah.
they would save. Thank you for that. Any further questions?
I just have a comment,
Oh, yeah.
actually. Yep. The Rockefeller Center at Dartmouth did a study, and it came out that the main issue was childcare responsibility,
Yeah.
and then transportation, then employment, and then forgot, and intentional skips was the last. So
Yeah.
it seems like we do have a problem, and the text alerts might help. Their study showed that it definitely does help.
Yeah. No, that doesn't surprise me.
Not at all.
Thank you. Thank you, and we would appreciate any further information, as you said.
Thank you.
Thank you. At this point, we're going to take a 10-minute file break and then come back. And at that point, I think I'd like to hear from the chiefs. And we are back on the record. At this point, I believe there's one more county attorney who wishes to testify. If you could just tell us who you are and where you are from, and I won't repeat everything we started with. You can just pick up from what you heard.
Thank you. I'm here for two reasons, maybe just to make a couple comments and to be available for your questions. And I'm happy to begin with one or the other, depending on what the chair. First of all, I hearken back to the last time we were here on bail reform in 2018. And there was a tremendous dialogue in 2018 regarding what the standard should be in New Hampshire. And the argument was essentially that there was a clear and convincing evidence standard that was mandated by Fergal. I don't know how clear it has become since then, but the Supreme Court has said that that is not the standard that we're required to use. And that's in Zuchowski, the case that we just recently had referenced. And that was part of the argument as to what standard we should use in evaluating detention decisions. And the Zuchowski case said in Fergal, we rejected the argument that Salerno sent a minimum standard for all bail inquiries. And then it goes on to say that the clear and convincing evidence standard is not required constitutionally in New Hampshire.
And was that the majority opinion you're reading from?
Yes.
Okay.
I would never read you a minority opinion. And in fact, that was information that I cited to the court recently in a bail argument that we had over a challenge to the constitutionality of one of the provisions of the bail statute, not of the bail statute itself, but of the bail law that allows for mandatory detention on life sentences. So I'm very confident that we are no longer required to use that standard. Second thing I would like to say is, I think the first question we have to ask when we're sitting here discussing bail is, what are we as a society willing to tolerate? And what I mean by that is we've had a lot of conversations about crimes committed out on bail. We've had a lot of conversations about failures to appear. Both of those things are huge problems. And both of those things are something that I think we should ask the question, how much of this and under what circumstances are we willing to tolerate it? In other words, is there ever an end to how many times you can not appear before there's going to be a presumption of detention? Under what circumstances are we going to say that crimes committed out on bail have risen to the level that we are no longer going to allow that person to be accessing bail? And I think those are fundamental questions that we have to ask as a society. And I think if we don't ask them, we end up talking tremendous amount about the why. The why is important, but at some juncture, it cannot be dispositive. In other words, society has an obligation not only to look at the offender and the impact that the criminal justice system's interaction with the offender has on him or her, but society also has an obligation to ask what is the impact on society on allowing this behavior to continue unchecked and be unwilling to check it. And I think that in many respects, the frustration that we hear about bail reform is about an unwillingness for society, as evidenced by the bail statute and perhaps more pointedly by its application, that we are unwilling to protect society as a whole. So I think that's a fundamental question that we have to ask. And then I think it's important that I just convey a little bit about where I come from on bail. I have no interest in cash bail ever. I think we should be making an in or out determination. And if we make an out determination early on in the process and nothing changes, that's perfect. But if we struggle mightily as a society to bring that person before the court, or if we struggle mightily as a society with that individual committing new crimes, we have to reassess the situation and make a determination that we are no longer willing to accept this level, either in volume or in seriousness, criminal conduct, in volume or seriousness of failure to appear. And all failure to appears are not created equal. For example, if you fail to appear the day of your trial, that's a biggie. But there's got to be a conversation at the legislative level about what those lines are. What are we willing as a society to tolerate? And I don't think that question is asked often enough. And just another quick observation is I've heard numerous times, last time I was here in 2018, and I've heard the question again, what about data? One of the things that we could do to generate data is to have the bail form that we use in court track the decision-making process that's in the bail statute. And that could be managed by the administrative office of the courts, and maybe there could be a computer program, and we could figure out how many no-shows, how many crimes committed out on bail. We don't have that data. We don't have the time or the energy to do the data entry in our office. It's a small office. But that data would be valuable to you. It would be valuable to any decision maker in this arena. And I think having that bail form track the statute's decision-making process would be very helpful. I don't know how many of you have looked at the current bail form that we use. It's really about a page and a fraction, and then a big space for the judge to sign. And it doesn't really track the decision-making process. And I think that would be helpful to everybody involved. If we knew from looking at the bail form that somebody was charged with an offense while out on bail, if we knew that there were prior failures to appear, and that those initial presumptions had been triggered, what we have is we have a one bucket line item that says essentially, we've decided that you're released into the community having evaluated this under the clear and convincing evidence standard, okay? So that's where I'm coming from fundamentally. Is I think the biggest thing that we need to do is decide what we will not tolerate. And I'm happy to answer any other questions.
Thank you. In the courts that you practice in, you heard the question I asked initially of the other county attorneys with regard to what are the types of crimes that are really triggering this problem of these repeat out on bails. And are you of the same opinion that it's these nuisance level crimes, these misdemeanors such as trespass, shoplifting, these type of things that are occurring on the repeat while you're on bail?
No, I think, are you, let me just make sure I understand the question. The question is, what is the crime being committed out on bail?
Yeah, what types of crimes? Because we have a list of 13 crimes the Senate proposed, and they're all very serious crimes with violence against the person. But what we've heard anecdotally is that's not what the people are being picked up on time and time again while they're out on bail. It's lower level misdemeanor crimes, some of which don't even carry a jail sentence were they found guilty.
First of all, I think that that's an oversimplification. We see a broad range of criminal behavior. I think there's a difference between a misdemeanor shoplifting first offense, committed on release, and somebody who commits a violation of a protective order that's a misdemeanor. I think we have to be able to rationally distinguish between those two things. And I wouldn't suggest that, one new crime committed out on release should automatically result in detention. But I think we should be able to quantify those crimes or identify those crimes that we certainly should make that leap. In other words, if you're out on bail and you commit one of these crimes, there will be a strong presumption or mandatory detention pending trial. I think that that's what society has to be able to expect. A criminal justice system that will act to protect the interest of the accused, the victim, and the defendant. And right now, for whatever reason, you can have people out on multiple layers of bail in multiple cases over a year and a half. And we never get to the point where we say society is unwilling to tolerate this. And there, I think the legislature has it within its capacity to identify those things that we will not tolerate and what volume of those things that are tolerable at a relatively low level are not tolerable at a high level. And again, I go back to it. I don't believe in cash bail. I believe that follow the rules out in the community. You're good. You're good to go. If you're dangerous, if you're committing new crimes, that's a different animal. If you're not showing up, that's a different animal. And I think we should focus on those things. And I also think we should focus on whether or not we have the right standard of review in the current bail statute.
With regard to that, the clear and convincing was what was there. Are you proposing preponderance of the evidence? Is that the next level that you would propose?
Yeah. I think that's a conversation that is worth having, because we've already started. Historically, probable cause, preponderance of the evidence, 51 versus 49, is the standard by which we charge people with criminal behavior and have done so since the beginning of time in New Hampshire. That's the standard that's in our Constitution. And we don't need a higher, more difficult standard to make bail decisions. What we do need to do is to decide when we want to exercise the power of the state and identify those things that are unacceptable to us as a society. And you collectively as the legislator have the power to do that. And I think that's what we need to do. Bright lines, in or out, and give the court the discretion to make these decisions. But I thought that the last bail statute gave something, in other words, the presumption, and took it away when we created a standard of review that was so difficult to achieve. And we failed to protect the community and the standard of review.
Any questions? Okay. Go ahead. Representative Catherine.
In listening to your testimony, I guess I'm sort of struggling because we have a list of RSAs here. Just so I'm clear what you're saying, these are ineffective. What we already have, that you can hold a person without bail. So
Well,
I just need to be clear about what you're
what
insinuating.
what I'm suggesting is that for virtually the entire history of the state of New Hampshire, these decisions regarding bail were made at a preponderance of the evidence standard, okay? And we are now making them at a much higher standard, and that logically creates an additional population that's in the community who would otherwise have been detained at a lower standard. And it's interesting that we create a presumption in favor of detention because these behaviors are unacceptable to us, and then we create a higher standard by which we're going to execute that direction that the legislature has given us. Detain this person, and then we make it harder to do that in the next step, which is the, clear and convincing evidence. If I'm unclear, I apologize.
Yeah,
No, I think, if I may, her question was with regard to specific crimes, not the standard of review. We have a list of 13 crimes proposed in the Senate bill that would not be subject to bail by a bail commissioner, that would have to be held by a judge. And I believe she was inquiring because of your statements with regard to how much will we tolerate, which crimes.
I think there's two different things. Okay, the presumption is that a judge is going to come up with a decision that is more likely to be protective to the community. I'm not sure that that's necessarily the case. The judges are wedded to the law; they do a good job. I think the question becomes: we're here because society is telling us that what we're doing is not working, that we are not protecting the citizens of our community. We're not protecting the integrity of the criminal justice system as the system is currently operating. And if that's true, we have to look at what we can do differently. And it is unquestionably true that we can have people out on bail, multiples deep, multiple crimes, on multiple new offenses, out on bail. It is an epidemic. You've heard from my brother's county attorneys today. People don't show up. This is unacceptable behavior, and we have to quantify what we're willing to accept as a society and say that there is a certain point, a certain level of behavior that we will not accept, or we're going to create a greater likelihood that society will hold you pending trial. And again, I am not one of these people who believes that everybody should get held. I think the presumption should be a strong presumption that people will remain in the community. But I think when you start committing new crimes on bail, that we really have to take a good hard look at what we're doing and make sure we're being effective. And people showing up. You can have hearings scheduled, 10 hearings scheduled, and you're lucky if you get 2 or 3 on status conferences. And we issue bail orders, we bring them in, and we start all over again, and we do it again. It is destructive to the integrity of the system. It is destructive to the integrity of the court, and it's destructive to the orderly process in giving justice to those who have been victimized and those who are accused.
Thank you for taking my question again. So again, to better understand your comments, you have RSAs. However, what I hear you saying, and tell me if I'm wrong, that the system is not doing what they're supposed to. Those that actually supposed to enact the law are not necessarily doing what they're supposed to do. Because if it's here and it says you have the right to do this about that person and it's not being done,
Well,
where is that happening? It's not happening in the law because it's in the law.
No.
So
Unless I'm mistaken, I do not believe you're referring to mandatory detention.
I'm talking of
No, you're-
whether you're mandatory or whether you're bailed or not bailed or those types of things.
There are very few circumstances in which there's going to be mandatory detention. In other words, the law does not give the court discretion to release someone. Okay? The vast majority of cases are there, the court has discretion. And the last time we were here creating legislation, we created presumptions in the law that said under these circumstances, they will be presumptively detained. Some of that had to do with conduct out on bail. Some of that had to do with the nature of the offense. And then we basically said we really weren't serious about it because we elevated the standard of review unless the court finds by clear and convincing evidence that. And it was the Lord giveth, the Lord taketh away. And the standard of review is as much a consideration as what you say you are prohibiting or presumptively prohibiting.
So if I, just for clarification, you're saying that, okay, we said we will not tolerate as a society A, B, and C.
They're presumptively detained.
Yes. And however, we're going to make you prove it by such a high bar that it's difficult to prove. Therefore, we really, but at the time though, were we not operating on the presumption that the clear and convincing was or may still be the standard or?
Well, I think that was what was argued to the, I know that was what was argued.
Mhm.
And that was not the law then. That is not the law now. It is clearly not the law now. I think that people had a good faith basis for making the argument that Fergal stood for that. I didn't believe it. Okay.
Has the New Hampshire Supreme Court opined on it to the best
Yes,
of your
that's the,
Oh, I thought you were reading a U.S. Supreme Court case.
no, that's the New Hampshire Supreme Court. The New Hampshire Supreme Court,
The Zelensky. Is that?
Zuhiski, that's
Zuhiski.
these motorcyclists, the 7 people dead.
Okay. Yeah.
That's the case. The New Hampshire Supreme Court said that the clear and convincing standard is not required. They said it essentially that it would be a misreading of Fergal to believe that's true. And I don't fault the people who looked at Fergal. And I'm not saying that the people who argued that position were dishonest. That's not the case. There was a legitimate, robust debate. I can tell you, and I believe that almost anyone who's practices law would tell you that that question has been resolved by Zuhiski.
In with regard to the U.S. Supreme Court, was that the Salerno case?
No,
that was, or there hasn't been a U.S. Supreme
there-
Court.
I don't think there's any U.S. Supreme Court case that would alter the discussions that we're having here. The argument regarding the burden of proof, which was one of the central arguments that we had back in 18, was over how we interpret the New Hampshire Constitution. Fergal was a New Hampshire Constitution case. It cited Salerno, which was a Court of Appeals case, I believe, from the West Coast. It was an Arizona Court of Appeals case to the Federal Court of Appeals. And that site created this conversation about the standard of proof.
So that wouldn't even apply to this district if it was from.
Well, no, but the argument was that it did, that that's what happened in Fergal.
Mhm.
Supreme Court said, no, that's not really what happened in Fergal. And it's very clear in Zuhiski.
We'll read that case. Thank you. Representative Muse, you had a question?
I had a question. You seem to be pretty firmly of the opinion that cash bail shouldn't be part of the system. And I am aware of other states where cash bail has been eliminated. I guess my question is to you, I know that some of those states have struggled in the same way New Hampshire has struggled, with things like non-appearances and things like that. What are other states doing that don't have cash bail that seems to be working? Aside from just simply having a fairly clear roadmap to follow in terms of.
What I guess is what I'm saying is, first of all, I'm not an expert on what other states
Okay.
have done. My dislike for cash bail is that it makes a decision as to somebody's liberty based on how much money they have, and that's really not what we should be doing. Okay, from my perspective. And if somebody is a good risk, and I think there should be by and large a presumption that most people are good risks, that they should be released on their word to appear and be good. And then society responds to the failure to appear and the failure to be good. And we ask ourselves, how much and what kind of failure to be good will we tolerate? And how many failures to appear will we tolerate as a society? At what point do we say that you are not meeting your end of that bargain by being good and by showing up? And I think there should be at some juncture a bright line where we say no longer can we tolerate this. You're detained pending trial. No longer can we tolerate this. You're detained pending trial. And what I see in the prior bail bill and how it is being applied as currently written is an almost limitless toleration for failing to appear and an unacceptable, oftentimes, toleration for new criminal behavior. And if I had to quantify or rate the importance, new crimes are probably far more important than failures to appear. I don't know what the number that the legislature would find intolerable on failures to appear, but I think the number of times you can commit new crimes without unconditional release should be relatively low. And I think there should be a gradation between serious criminal offenses, felonies, and assaults, violations of protective order, even if they're misdemeanors. Those kinds of things we cannot tolerate as a society regularly out on bail and maintain protection for our community and respect for the system.
Thank you.
Seeing no further questions, thank you for your testimony today.
Thank you.
Chief, would you like to?
Good morning, Mr. Chair and members of the committee. My name is John Berfonsky. I'm the chief in Bedford and currently the president of the New Hampshire Association of Chiefs of Police. And I thank you for the opportunity to provide you with some information today that perhaps you don't have that may be germane, well, not maybe, but will be germane to your discussions and deliberations with respect to bail reform. And first, I'd like to mention that the previous County Attorney Hathaway, I can't echo his comments and in full support of the premise upon which he bases his opinions and his concerns, which are totally shared by the chiefs of police. But what I want to bring to you today is information that is particular to New Hampshire, and it goes to the questions and discussions that you've heard quite often about people that have been arrested and released and arrested and released. And so while we haven't had a system by which the state or law enforcement agencies can tabulate those numbers with any degree of accuracy. I'm here to tell you that the state actually did enjoin a contract with the Council of State Governments in 2022, and is called the New Hampshire Justice Reinvestment Act, an initiative. And essentially, what that initiative did was to, under contract, require the National Council of State Governments to look at the high utilization and persistent utilization of county jails throughout New Hampshire, and to determine why this was happening, and perhaps develop some key points and elements. So very briefly, without keeping you long, I think this information may be very helpful to you, and I'll provide the committee with a copy of this as well before I leave. Essentially, there were three challenges that the state identified. One, that there's a small number of people cycling through the jails in New Hampshire that are utilizing a substantial number of resources at great cost to the counties and to the state. Two, high utilizers of jail services had more complex and more frequent behavioral health and other related encounters than non-high utilizers of jail services. And thirdly, and this is something that was discussed previously today in your committee, that reentry and community services vary greatly from county to county in New Hampshire, contributing to long wait times and significant gaps in reintegration services, particularly for the high utilizers of jail resources. So here are some essential key findings, and these are numbers that I think are both starking and revealing. Jail high utilizers accounted for 9% of the jail population, but actually 34% of jail entrances and approximately 29% of jail costs for fiscal year 19 to 21. Let me say that again. 9% of the jail population accounted for 34% of the jail entrances. That means that a relatively low number of people are cycling through New Hampshire county jails over and over and over again, which is consistent with what you've heard from members of law enforcement, myself, as well as county prosecutors. Now, of those 9% that account for 34% of the jail entrances, remarkably and sadly, 84% of those 9% were diagnosed with a substance use disorder as the primary diagnosis. Now, this information is coming from Medicare data that was obtained by the Council of State Governments. So these are actually diagnoses that were obtained as a result of medical records. So 84% of that 9% presented with a substance use disorder, and 69% of the 84%, right? 69% of the 84% presented with opioid-related primary diagnosis, right? And interestingly enough, only 33% presented with alcohol-related primary diagnosis, right? And behavioral health constituted 73%. So overall, 89% of the high utilizers in fiscal years 15 to 21 had a history of Medicaid enrollment, and of that population, 93% had a behavioral health claim. So what we're seeing here is factual data as a result of this study that is particular to just New Hampshire now. This is just New Hampshire with respect to those folks that are cycling through county jails over and over again, that are accounting for a high number of jail entrances, but actually are very less than 10% of the population. And of that population, a significant amount of those folks, over 80%, 84% actually, were diagnosed with an opioid-related substance use disorder, or a substance use disorder, and 70% had an opioid substance use disorder diagnosis. The takeaway from the law enforcement perspective, and again, I'll provide the committee with a copy of this, is that this validates the concerns that you've heard from County Attorney Hathaway and myself and others in law enforcement regarding folks that are cycling through the system over and over again. And so the other key elements that were obtained as a result of this study, in comparison to the non-high utilizers, the high utilizers in fiscal year 19 and through fiscal year 21 had a greater likelihood of being booked into jail for lower level crimes such as criminal trespassing, probation, parole violations, and failure to appear on bail charges, and were less likely to be booked in for violent crimes. So there are two distinct issues that I think are presented for you as a committee to look at. One is the concern of the community and society has on how people that are charged with violent crime are handled initially through the bail system. And secondly, this particular study looks at and validates the concern for those folks who are committing low-level crimes that are cycling through the system over and over and over again. And then finally, the key takeaway is that, and we know from law enforcement, that most of those folks that are charged and processed through the system, certainly at least in our county, in Hillsborough County, the most populous county, are committing those crimes and having an underlying substance use disorder diagnosis, right? But yet they're continually released. Bail orders oftentimes, and most oftentimes, require the individual who has that underlying substance use disorder that was brought to the attention of the court, typically by a defense counsel, places that individual on orders to seek treatment. And in the vast majority of those cases, those folks don't seek treatment. They reoffend, fail to appear, they miss their court dates, and they cycle back through the system again and again. So one of the areas that we've explored, and some counties are exploring it. I know Hillsborough County, the superintendent of jails, is looking at a incarcerative program that would interrupt the cycle of offending and release by folks who have an underlying substance use disorder by requiring them to be committed to jail for a period of time to undergo a medically assisted, proven, successful drug and substance use treatment program before they're released. That would interrupt the cycle of 89% of that 9% that are cycling through the county jails over and over and over again. So very interesting numbers. This is, again, germane to New Hampshire, and I think it is important for you folks to hear, and thank you for the opportunity of giving it to you today.
Chief, if you could, for the benefit of the committee, those were jail numbers, not prison numbers. So could you talk about what offenses are sentenced to jail versus prison? So we're talking those are mostly misdemeanors, or at least that they pled to or accepted time for. Is that correct?
That's correct, right.
So for the benefit of the committee, if you're sentenced for a felony, you go to state prison. If it's a misdemeanor or you plead to a misdemeanor that used to be a felony, you end up in the jail system. So those numbers applied mostly to the offenses that we're discussing as far as the burden on the system. And did you have anything else you wanted to add based on what you've heard here today?
No, this is all, County Attorney Hathaway did a remarkable job in putting the problem in perspective before you as the committee. To get a more strategic and 50,000-foot level, to try to get our arms around what is facing us, that has led to the perception that the criminal justice system is more of an annoyance than it is a corrective mechanism in society, is based on the lack of respect of that system due largely in part to the fact, and it is fact, that most people are not incentivized to follow the law because of a lack of consequences, right? And so what we see here is in these numbers a clear, remarkable manifestation that a number of people, a small number of people, as County Attorney Hathaway had indicated, are responsible for a high number of reoffending type of crimes. So those are the folks that we need to focus on, not the other 91% of folks, but we need to focus on that 9% that are accounting for 34% of the jail entrances. And again, these are jail entrances, not arrests. So that means that these folks likely have been arrested, released on PR bond a number of times before they actually land in a county jail. So that's another consideration that I think needs to be brought to light here.
You discussed a mandatory substance abuse program that would be taken care of while you were incarcerated. That's post-conviction, I take it. That wouldn't be while you were on bail. What services are available that you're aware of that could be used while someone was on bail? For example, someone's arrested, bailed, picked up again, and it's determined that they have a substance abuse problem versus saying, okay, we're going to hold them. What's available as an alternative to actually interrupt that cycle while they're on bail by sending them somewhere for some type of services?
As the study indicated, those services vary greatly and widely by county. Some counties have a more robust pretrial service and oftentimes a reintegration program, and other counties, based on volume and staffing issues, have much less. So one of the recommendations certainly would be to have the state look at providing for a consistent, well-funded, defined pretrial service system throughout all the counties to be able to better serve folks. The introduction of opioid abatement funds, which are now flowing into the state every year, we believe could be used to support the development and the deployment of medically assisted substance use treatment programs in county jails that I believe in my years, 27 years in drug law enforcement and 45 years in law enforcement per se, suggests to me that folks that are under bail conditions because they have a substance use disorder and continually refuse to avail themselves of the treatment and recovery systems that are out there today, much more so than there were 6 or 7 years ago. So those services do exist, but they frankly ignore them and they reoffend. A medically assisted incarcerative treatment program would be available, hopefully, funded through this opioid abatement fund to be able to interrupt that cycle. And again, as Attorney Hathaway indicated, this is not for the very first time that a person is arrested for a low-level crime and has a substance use disorder diagnosis. This would be for those folks that are in the gap between multiple offenses and releases and those that are then eventually sentenced to drug court. Because the drug courts, which do work well, unfortunately do not have the capacity to deal with the tsunami of folks that, as these numbers indicate, are producing in the state. So something in between where we're simply releasing folks with a substance use disorder and they are not availing themselves of treatment, and then waiting 1 or 2 years where they've accumulated a whole range of offenses and releases, and then perhaps maybe put them in drug court. Let's stop that cycle before it gets to the point where it's gone well beyond what's, as Attorney Hathaway so aptly put, society is willing to tolerate.
Okay. Questions? Representative Muse?
I wanted to thank you for bringing that report to light, and I also wanted to let the other members of the committee know that this was actually the report that I sent out to everybody about a month ago when we started. So I think this is one of the maybe the single most nagging systemic issue that we're dealing with currently, and unfortunately, there doesn't seem to be any super reliable way at this point of dealing with it. I know that when the commission made its recommendations, there were some people who looked at them. I was one of them, and I think a huge question for us is where we go from here, in the context of trying to rework our bail laws. I think it becomes easier for us to do that if we know that there's a way we can actually do what you're suggesting we do, which is to try to find a way to break this cycle. So I am 100% in favor of anything that that can do that. But one question I did have for you is, in terms, so breaking the cycle seems to be something that we can do. It seems to require a conviction to do that. This doesn't seem we can't presume people are guilty of an offense before they've been convicted in a court of law. Are there ways that you've heard about in your conversations with other chiefs or national organizations, how other states, other localities may be finding a way to get people some help before conviction? And I think one of the things we've heard about are various pretrial programs. So one of the things that I'm curious about is, how are so many people falling, kind of into those cracks, even though those programs exist? What's happening? Where are the holes that we need to close? I guess that's my question.
Thank you for your question, and I hope if I understood it properly, I'll try to address. I think there's a couple of questions in there. One relates to how to address pre-conviction those folks who have a underlying substance use disorder that is driving their criminal behavior to a large extent. And we here in New Hampshire, if we for a moment dial the clock back to 2014 and 2015, when the opioid problem began to surface in a large way in the state of New Hampshire, we were not in a position in the state of New Hampshire to be able to offer with any degree of certainty or regularity substance use treatment or recovery services. In fact, I can recall at a conference at the Bedford Village Inn, there was a speaker, and that speaker was from Florida. And in doing some research, I was able to determine that there were more treatment and recovery beds in the city of Tampa, Florida at the time than there was in the entire state of New Hampshire, right? But since then, we've come a long way in providing for services, treatment, and recovery in the state of New Hampshire. Some may say that we're not where we are yet or where we should be yet, but we have come quite a long way. The problem that you bring into discussion is the individuals or segment of that cohort that are facing criminal charges with an underlying substance use disorder and have been told by the court that you need to treat that, and yet they fail to avail themselves of the court-ordered treatment that is required to address their underlying diagnoses. That goes to the psychology of drug addiction and the state of substance use here in the United States. And as some of the members of the committee may know, I spent 27 years with U.S. Drug Enforcement Administration. And so I have quite a bit of knowledge about that area of psychology and criminal element. And I can tell you that the substance use problem that we face today here in the United States is worse than it's ever been in the almost half century that I've been involved in law enforcement across the country. With more than 110,000 people dead from drug overdoses. Most of those, not all, but most of those folks from disadvantaged communities, is a stain on the American flag. And we're still struggling to try to deal with this, and yet haven't found the solution. One thing I can tell you, and I think it comes from both my experience, ladies and gentlemen, as well as simple common sense that you all possess. And that simply is this. Today, the powerful nature and addictive nature of the drugs and the morbidity associated with the drugs that are available on the streets of Concord, New Hampshire, not far from where you're sitting, or on the streets of Manchester, or most communities in New Hampshire, are so powerfully psychologically as well as physiologically addictive that people will risk their lives on a daily basis multiple times, knowing full well that this could be the last time that they take a drug or a breath of air on this earth. And yet they still continue to be engaged in that behavior. There is no amount of criminal incentive that's going to stop someone from engaging in that behavior. So what do we do? And I think these numbers that you sent out to your committee give us a glimpse of what we may be able to do, because there are effective substance use treatment programs out there today, right? There are. And we need desperately, ladies and gentlemen, need to leverage the criminal justice system to take people who are continually engaged in this destructive behavior that costs so many lives, more than 480 in the past couple of years per year in New Hampshire, and we're on the trajectory to at least meet that this year. To take those folks and say, we know that this addictive nature of this type of problem that you have is not something that is most people can bring themselves to address themselves. So what we are going to do is we're going to use the criminal justice system as a lever to say, look, while we have you as a result of this criminal charge, and we know that you have this problem, here's a program that is 67 to 73% effective in solving that problem that is causing you the destructive behavior. Why don't we do that more often? The funds now, we used to say that we didn't have the money. It's expensive. When we first started to have the opioid problem in New Hampshire back in 14, 15, and 16, I believe Rockingham County was leading the charge with incarcerative treatment programs. And it was a really good program, but it's costly. Now we have a lot of money coming in by truckloads into the state of New Hampshire from the opioid settlements. Why don't we use that money, right, to interrupt the cycle of criminal behavior and address at least in 80% of that 9%, the underlying substance use disorder that's driving that criminal behavior? If that's successful, based on the numbers that you see from these medically assisted treatment programs, such as the one that's used in the Maine state prison that the federal government is looking at, as an example, right? We would substantially reduce the number of people that are offending, tying up criminal justice, police, courts, pretrial services, and jail resources. And they would be productive members of society. If we can just bring that number down by half, not even the 60 or 70%, it would be a remarkable improvement in where we're going. But to be able to do that, this committee needs to look at ways of allowing the criminal justice system to be able to operate more effectively, as County Attorney Hathaway so aptly stated, by reducing the tolerance of what society is willing to allow up to the point of limitless reoffending, which people will do if they have an underlying substance use disorder that drives them to the brink of death 3 or 4 times a day.
And follow up? Turn my mic back on. So it sounds like one of the things that you would support would be diversionary programs for people who have substance abuse issues, who are frequent offenders. Is that correct?
That's correct. Diversion programs for those folks, but it would be court-ordered, mandated, and for certain people that continued to reoffend and not avail themselves of treatment. So in other words, they have already presented a history of being told you've offended, you have this underlying substance use disorder, you've been ordered into treatment 3, 4 times, you have not fulfilled that obligation. So now the system, criminal justice system, is going to say you are now going to be in an incarcerative, so you don't have a choice, medically assisted treatment program. That's the key element.
Follow up? So in terms of actually implementing a system like that, it sounds like that's something that if we adopted it, we might want any judge in New Hampshire to be able to do, not just a judge in a drug court, correct?
That would be any judge, absolutely, because by the time these defendants reach drug court, they have amassed a trajectory and history of offending and reoffending that is substantial, much more than, what we see here in these numbers.
One more follow-up, and by judge, I think, are we talking about just a judge? So looking at, some of our conversations around bail commissioners and folks like this, should a bail commissioner have the ability, maybe this is something that appears on a checkoff. So instead of a cash bail, it could be participation in a program like this. Or would a bail commissioner even have knowledge that a person is a frequent offender?
The bail commissioners don't have the knowledge or the ability to be able to make those kinds of decisions. The bail commissioners that make the right decisions across the state are the ones that we don't hear about, and the cases that we don't hear about. The bail commissioners that make what we consider to be less than optimal decisions with respect to releasing folks that have allegedly committed a violent crime are the ones that I think that we talk about. And so what we're really looking at here is designing a system that provides a bit more direction, a bit less discretion, bit less, not a lot less, but a bit less discretion that allows the courts and the system to be able to be more effective in dealing with folks that are presented in basically 2 categories: those that are alleged to have committed violent crime, and those that are reflected in these numbers the 9% that account for 34%, which are those that continually reoffend, the vast majority of those with a substance use disorder.
And Chief, if I could, so I don't think you'd find much disagreement on this committee that those things are necessary with regard to the treatment off-ramps. But were it to be law this minute and a judge were to say, okay, you are going to this mandatory service, are there such places? Do we have this set up? I mean, how far out are we looking before we could even implement such a system where these folks could go?
Some of these programs currently exist in some counties. I know that the superintendent in Hillsborough County is seeking to establish a medically assisted incarcerative treatment program in Hillsborough County. And so I would hope that there would be leadership at the state level within the courts and others to make sure that this opioid abatement money, or at least a portion of it, is being devoted to standing up what appears to be very effective treatment programs in the county jails. That has to be in place. The judges will not sentence someone to a program that doesn't exist. And that's frankly been one of the problems, right? The judges do have folks before them, but if there's no incarcerative treatment program available, then oftentimes those folks are sentenced to a term of incarceration, all suspended, and then told to get treatment outside the system, which they typically don't do.
With regard to mental health, again, it goes back to available beds. I know we just completed a facility, but disappointingly, I think it ended up with like a handful of beds versus the hundreds we would need. Are you aware of anywhere that are not government ordered or run that these folks could be sent to get back on their meds and treatment and things of that nature?
That is probably one of the largest gaps that we face here in the state of New Hampshire, and I don't think New Hampshire is different than most other states. The mental health gap in terms of facilities and the ability to be able to treat as well as provide services to folks who have a mental health diagnosis and to follow them through is largely non-existent. And I think that, again, the study points out the wide differentiation, divergence between the existence of pretrial services throughout the state. That mechanism could provide some degree of a stopgap measure, as I think you're indicating here, to help along with the system for those that suffer with a mental health underlying disorder.
Thank you for your testimony. We
Thank you
appreciate
so
it.
much.
Oh, Representative?
I'm not on the subcommittee, but they're nice to me. So I can't disagree, of course, with the dialogue that you and Representative Muse had. But one thing that has caught my attention is, can somebody be forced into a program? We can incarcerate them, but what are you going to have? Just because you're well-intentioned and it's effective, will they cooperate? Just some people won't. What do you do? Can they be, my question is, can they be forced into a program even post-conviction?
Well, thank you for your question. And I think that what we see in the numbers is that when an individual is released under bail conditions, some of which require the individual to seek substance use disorder treatment, we find that significant, in fact, a majority of those folks don't seek that treatment. The system, the courts, can mandate them to participate in, much like the system that is currently in the Maine State Prison, a medically assisted treatment program. Now, again, it's not 100% effective, but it can force the individual to be in the program. Whether or not they succeed is largely up to them.
Thank,
Thank you so much.
I believe, last but not least, I'm going to give Professor Scher 10 minutes of our time before we go, as you requested. I had to put a limit on you.
It's a good limit because I have to be at school at 1 o'clock. I agree with a lot of what's been said today, with one exception. I've known County Attorney Hathaway for over 40 years now. Sad commentary on both of our ages. And he's wrong that there are not mechanisms in the current bail statute to deal with people who fail to appear repeatedly, to deal with people who are violating bail conditions. They are there. And I think this committee is sophisticated enough at this point in looking at the statute to know that they are there. I will pass out to the committee a copy of 597-2 with 3 areas highlighted that deal with that circumstance. Because, and I'll do it after I finish testifying, because it's there. And so I don't think the problem is the statute. You've heard this from me several times. The problem isn't the statute. The problem is implementation, be it educating judges, be it educating bail commissioners. That's the problem. Part 2, I agree medically assisted treatment while incarcerated can be effective, but it's when people are sentenced. It is very difficult. Let me put it a different way. The best way to deal with those with possible substance abuse problems or mental health problems is to use that opioid money for pretrial services in every county. Because if you don't do that, you're leaving it to judges to diagnose whether somebody has a mental health issue, diagnose whether they have a substance abuse issue, and they're not good at that. We don't want that system. So yeah, I think potentially if we have a pretrial service system in every county where professionals can do that diagnostic behavior, then we start to have a bail system that works. Remember, we're not talking about people who are sentenced. And my belief is, I haven't read the report, but my belief is the numbers the chief talked to us about primarily covers people who have already been sentenced, that really aren't talking about pretrial people. And those numbers are no surprise whatsoever. But I think we're not talking about pretrial people. The repeat offenders that keep cycling through the jail are cycling through the jail on sentences. I'm going to my list. You've heard this again from me, but the bail commissioners by statute have all the authority that judges have as to bail. They do. So any sense that the bail commissioners really don't have the power to do X, Y, or Z is not the case. I would suggest that police begin to consider, given their concern that they don't have enough information about an individual to really provide all the necessary information to bail commissioners or even judges. Well, for those people who are not immediately dangerous and they need to get off the street instantly, instead of arresting people as soon as they can, maybe take an extra day to gather bail facts, to run a prior record, to see how many failures to appear this person has, to find out more about this person for making a bail argument, rather than arresting them as quick as they can and not having all the information that would allow them to make an effective argument to the bail commissioner or a prosecutor to a judge. You know, no question there's some crimes they have to arrest them immediately for, but I think that's a proposition worth considering. You know, I disagree with the interpretation of the that County Attorney Hathaway did of the clear and convincing standard. You know, the Fergal case, which was referred to in that case, in the case he mentioned, whose name I'm not even going to try and pronounce, that begins with Z. The Fergal decision was a the clear and convincing standard didn't exist in New Hampshire back, other than in homicide cases, except back in 2010 when Fergal was decided. So I point that out. I think I'm almost done. There is a lot of data, and the court has this data, that a texting system for reminding people that they've got a court date coming up has been shown to be very effective in various circumstances. I think there's a great study out of Pittsburgh, the city of Pittsburgh, if I'm not mistaken. The court system, the district court system, several years ago, set up a pilot program in Rochester District Court to do that, and then the pandemic hit, and it didn't make any sense at that point for all sorts of reasons. So the court had set up a test of that texting system, and I think it's worth talking to them again about. You know, I think I'm almost done. One last thing. I think Attorney Halverson, Attorney Enders correctly said when asked, the majority of people out on PR bail are not a problem. I think let's keep in perspective the nature of the problem we're dealing with. The huge majority, I believe, of people who are out on PR bail are not a problem. We're talking about a small group, and we're talking about a small group for whom bail commissioners and judges have the authority under the statute to deal with the circumstance. And for whatever reason, you know, we've had discussions in various ways about this, the bail statute hasn't been used to do that. Just one last example. If you look at, where is it? The bail statute, Roman numeral 3, when in the provision that talks about assuring the court appearance of charged persons, paragraph 2 says, if the court determines by preponderance of evidence that a person has failed to appear on any previous matter charged as a felony, Class A misdemeanor, or DWI, or reasonably equivalent offense in an out-of-state jurisdiction 3 or more times in the past 5 years, or twice on the present case, there shall be a rebuttable presumption that release will not reasonably assure the appearance of the person as required. So 2 failures to appear on the present case, and the court's got a lot of authority to deal with that. Again, an example of we don't need to work the bail statute over significantly because it's already there. There's some other systemic problem, be it education or whatever, be it education of prosecutors, of judges, of bail commissioners. That's the issue. And last, I'll repeat, pretrial services in every county would make a huge difference. And I'll hand this out. I almost got
Sorry
out.
about that. In the current statute, one of the things that it does say is, and you took us through part of this, if the court determines by a preponderance of the evidence that a person has failed to appear on any previous matter charged as a felony, Class A misdemeanor, DWI or a reasonably equivalent offense in an out-of-state jurisdiction, then it lays out, you know, 3 or more times within the past 5 years or twice on the present case, there should be a rebuttable assumption that the release will not reasonably assure the appearance of the person as required. So currently, we're talking about felonies, Class A misdemeanors, driving while impaired, other offenses. A lot of the offenses that we're talking about, though, you know, by the people who have regular encounters with the court system, would not fall into that category.
I think the ones we worry most about would.
Okay.
You know, there are violations that on Class B misdemeanors that account for some of those. The problem there is of a different order, a different policy question. Neither violations nor Class B misdemeanors, even if you're convicted, you're not going to get a jail sentence.
Right.
So to hold somebody pre-trial on a charge for which, assuming they have multiple failures to appear, that they're not going to get a jail sentence with, that's a difficult thing. Arguably should never be happening. But you know,
that raises a question though. Is contempt of court jailable?
yes,
So failure to appear theoretically could be charged as contempt of court.
it could be charged with contempt of court. So yes, I mean, I don't, you know, one needs to, judgment needs to be used as to whether if someone is committing repeat violations like littering, we ever want to, you know, put them in jail for any period of time whatsoever.
Louis?
Paul Halverson from Merrimack County again. I asked Attorney Enders to come up with me because he actually did the litigation on the issue I'm about to point out. The chief pointed out the issue of pre-trial court-ordered mandated treatment for addiction issues. And I tie this into the bail statute because there's a direct reference in this title I'm about to tell you. Under 172.13, which is under the New Hampshire Substance Abuse Disorder System statute, there's a mechanism for the courts to refer an individual to Health and Human Services for evaluation and recommended treatment. We tried to do that in a recent case. Individual was clearly a substance abuse user. The judge even commented from the bench that it was clear. Yet, for some reason, the court declined to make that referral over to Health and Human Services. Without going into details of that specific case, the part of 172.13 that ties into bail is that if the person is made that referral, goes into the treatment, the court may release the person conditionally for treatment at any alcohol, drug abuse clinic, certified facility, mental health clinic, or center, or other appropriate sources of care. So there's already a mechanism for individuals who have a demonstrated substance abuse issue to be released pre-trial, even if they're being detained for substance abuse treatment. Now, the difficulty, and I'll defer to Attorney Enders to elaborate on this because he had the actual discussions with HHS. It's my understanding that HHS has no internal process to process that individual if the court makes a referral. I see that as a real stopping point. It's an avenue that's available, but it's one that's not executable. It's available by statute, but not executable by the organization. I don't know if Attorney Enders wants to elaborate a little on that.
And by that, you mean no drug screening, no ability to conduct drug screening, that type of thing?
The statute itself, and again, this is 172.13 paragraph 2, actually says, when a person is indicted for a felony or is awaiting the action of the grand jury on any felony or is charged with a misdemeanor, and question as to the drug or alcohol dependency of the person is raised by either party, Any justice of the Superior or Circuit Court having jurisdiction over the matter may, after hearing, order such person to be examined in accordance with the instructions of the Commissioner to determine whether said person is drug or alcohol dependent. The Commissioner shall report the results of the examination and his findings to the court in writing. And the Commissioner, there's the Commissioner of DHHS. The next paragraph, paragraph 3, reads, if a person examined pursuant to the provisions of paragraph 2 is found to be drug or alcohol dependent, the Superior Court having jurisdiction over the criminal action may, after hearing, without regard to the results of the criminal action, issue an order requiring the person to accept treatment at a certified substance abuse treatment facility when an opening becomes available. During treatment, no further action shall be taken in respect to the original charges made against such person unless otherwise ordered by the court. The court may release the person conditionally for treatment at any alcohol, drug abuse clinic, certified facility, mental health clinic, or center, or other appropriate sources of care. I had, as Attorney Halverson said, filed asking that someone be evaluated and called DHHS and said, is there anything I'm supposed to put in this order? And they essentially told me, we don't do this. I explained, well, the statute might think differently. And they told me I was reading the statute wrong. And I said, you might want to take a look at it. And they're like, oh, it does say that, but we don't have a process in place for this. So again, the statute exists that allows you to essentially pause a criminal case and order a defendant into substance abuse treatment through DHHS. Whether in reality you can do that or not is, I think, a different question.
The role of DHHS would be simply to screen and tell the court whether the person indeed did suffer from a legitimate mental health, or so they could theoretically easily farm that out. They don't necessarily need to build an infrastructure of their own to do it. Is that not the case? Or at least sound reasonable?
It certainly strikes me that the statute anticipates the Commissioner ordering this person to be evaluated, and then the Commissioner reporting back to the court on the results of that evaluation.
Yeah.
I-
How long ago did you encounter this?
Less than 6 months.
Couple months.
And the difficulty is, I was told we might be able to, we would tell the person to get an appointment. And I explained, we might be dealing with a mentally ill homeless person who's unlikely to follow through with that appointment, which is why we would be at, essentially why the person's perhaps in the criminal justice system to begin with. And
Interesting. Okay. Thank you. We'll look
there
into
certainly
that.
is a statute that exists.
Yeah, it seems like maybe perhaps direction to the DHHS that they order said person report to a hospital or wherever where such screening could be
Right.
carried out.
Well, they would make that recommendation to the court would make the order.
I meant for the screening portion
Yeah.
of it.
Right, yes.
Yeah, and
yes.
if they have Medicare, then the hospital could bill Medicare, and that wouldn't, yeah,
Right.
we'll look into that. Thank you. Did you have something here? I thought- Okay.
And the last point I would make is that the new superintendent of Valley Street, the House of Corrections down in Valley Street, was a former superintendent in Merrimack County. He's acutely aware of the programs that he started in Merrimack County, that he's now trying to start down in Valley Street. I would recommend that the committee consider sending an invitation to both of those superintendents to see how they've established those programs, how they work it with bail and release.
Those invitations have already been extended. So
Thank you.
we look forward to hearing from them.
Thank you.
Thank you both. We appreciate it. And before anyone else raises their hand, we're closed today. Oh, you had a question? I meant people in the audience. Hold on to it for next time.